Compliance webinar, Taking Adverse Action, How to Stay in Compliance. My name is Sarah Van Gilder, and I'm the Marketing Manager here at Corporate Screening. And I just wanted everybody to know we're pleased to be able to present this webinar to you today. I wanted to begin with a little bit of housekeeping. During the webinar, you're going to be muted. If you do have any questions that you want answered immediately, you can send them via the question box on the webinar screen. I'm going to monitor the questions throughout the presentation, and at the end, we'll hold a question and answer period. So if I don't get to your question during the presentation, we'll get to it afterwards. At this time, I'd like to introduce you to our presenter, Kevin Neudecker, who's the Compliance Manager here at Corporate Screening. Kevin's been a member of the Corporate Screening team for over 13 years and is FCRA Advanced Certified by the National Association of Professional Background Screeners, which is also known as the NAPBS. In his role as Compliance Manager, Kevin develops policies and procedures to ensure corporate screening remains compliant with federal and state laws regarding background screening. He also oversees corporate screening's continued compliance with NAPBS accreditation standards, and he spearheaded corporate screening's effort to become one of the first accredited consumer reporting agencies with the NAPBS. So at this time, I'm going to turn the webinar over to Kevin, and he's going to tell you all about adverse action. Thank you. Kevin, it's yours.
All right, thanks, Sarah. Welcome, everybody, to the first of our monthly webinar education series that we're going to have throughout the year 2017. So look for some other topics coming up here in the near future. So we have quite a few attendees today, which is good. So I think this is a good topic for us to start off on. So just a legal disclaimer that I'm sure most of you are used to whenever you take part in one of these presentations. So the information in the webinar today should not be construed as legal advice, guidance, or counsel. You should consult with your own attorney about your compliance responsibilities under federal and state laws. So some things to remember as we go through this presentation. The Fair Credit Reporting Act is the law that governs background screening, including the role of screening companies, which is corporate screening, and your role as an employer. The FCRA is a consumer protection law, so in that law, the job applicants are considered consumers. In the presentation, we'll refer to them as applicants because that just makes more sense to the relationship that we're discussing. So judges and juries are likely to be sympathetic to the applicant, putting the burden on companies and employers to demonstrate compliance when it comes to the FCRA. Applicant experience is very important to employers, and this should extend to the background screening process as well. And I'm a big proponent that the background screening process should be a transparent one. Applicants should know that a background screening is being done on them. They should know what the results are. They should have access to those results. So the FCRA requires certain actions from employers when taking adverse action based on the results of a background screening report. So adverse action is, failure to hire an applicant, and it also can include, denial of retention or promotion of an existing employee. Well, that's not as common. There are occasions where, additional screening is done on an existing employee to see if they meet the requirements for a promotion or a transfer. So anytime the information in a background screening report is the basis for an adverse decision, you must follow the adverse action procedures dictated in the FCRA. So this includes, denying employment due to inaccurate information on a job application. So an example might be the person did not disclose that they had a criminal record. One is found on the report. You still need to follow the adverse action procedures because you are using that information in the report to make the adverse decision, even if the criminal record itself is not the reason that you're denying the person. This also includes non-criminal information in the report that was evaluated and determined to be the basis for not hiring. So much of the focus when it comes to adverse action is often on criminal records. Just want to make sure that it understands that it's not just criminal information in the report that requires adverse action procedures. If there's other information that you evaluate and determine that you can't go forward with hiring the person, you still need to follow adverse action. So just to give you some idea of the legal landscape surrounding this, employers not following adverse action procedures is a common basis for lawsuits, including class action lawsuits. A recent one came out a few weeks ago against Starbucks, alleging that they did not follow proper adverse action procedures. And as somewhat related, a recent Supreme Court decision, plaintiffs are less likely to be successful with lawsuits based on disclosure and authorization violations. So the idea here is that plaintiffs' attorneys will start to turn to other parts of the FCRA that are commonly violated to bring suit against. And the most likely one after disclosure and authorization forms is companies not following adverse action procedures. Part of the reason for this is that the fines for violating the FCRA can be quite hefty, $1,000 per occurrence, which may not sound like a whole lot, but when you consider that, when you add it into a class action lawsuit, those numbers add up very, very quickly. So the adverse action process consists of 2 parts. There's a pre-adverse action notice and an adverse action notice. So the pre-adverse action, you are notifying the applicant that there's information within the background report that is likely going to lead to an adverse decision, generally not hiring that person. The letter goes along with a copy of the report, a summary of the rights under the FCRA, and any state-specific notices that may be required. And it notifies the applicant of their right to provide additional information or to dispute the information in their report. So the second part is the adverse action process, which is the actual, adverse decision being made, taking away somebody's job offer or whatever the adverse action is. This occurs at least 5 days after the initial pre-adverse notice, and this includes a letter telling, detailing to them what the final decision was. And we also recommend that at this time you, send another copy of the report and any of the state-specific notices. So as we'll go through, we'll kind of, go through the steps to get to each part of the 2-part process. So following the adverse action procedures is important just beyond your legal requirements. Most errors in reports are not the fault of the CRA, which is corporate screening, a consumer reporting agency, or the fault of the applicant. Most errors that we find are due to inaccurate information that was provided to us from a reporting source like a school, an employer, or corporate records. So it just makes sense that the applicant should have the opportunity to identify those errors and get them corrected. So this helps ensure that you receive the best information, which in turn helps you find the best candidates for your position. It also adds, you've already invested a lot of time and money into recruiting and interviewing and screening an applicant. So likely the last thing you want to do is get somebody that far along your process and then have to deny them employment. By following the adverse action procedures, you're not only complying with your legal responsibilities, but you are benefiting your company's bottom line. So you don't have to start the whole process over if the denial was going to be based on some information that may not have been accurate as was reported from a school or an employer or a court. So making the decision. Before you make the decision, you have to decide if the decision is warranted. I would say that if these decisions are not easy for you to make, you're already making a step in the right direction because that tells me that you're taking some care in making these decisions. So when it comes to adverse action, questions you should be asking yourself right now is, do you have a process? Is your process consistent? And is your process documented? So do you have a process? I'd say if you don't have a process, you should immediately, maybe after this webinar, take the steps to start putting one together. Your process should consist of 3 major components. Who in the organization makes the decision, how is the decision made, and how are the decision and subsequent notices distributed and documented. So who makes the decision? Just a note, at this point in the process, you're not making your final decision. You're making a preliminary decision based on the available information. As you'll see, as we get farther along the process, there's an opportunity for the applicant to respond to your initial decision, which then have to be assessed by your organization before making your final decision. So some employers have a committee that reviews each situation before a decision is made. Some have an in-house or outside counsel that review decisions. Generally, the fewer people that are tasked with making a decision, the better chance for compliance. So if you have 20 hiring managers and they all have the authority to make an adverse hiring decision, it can be difficult for the organization to maintain a compliant and consistent program. So if you already have a process in place, this might be a place where you want to revisit if you've got a lot of people that have the authority to make this decision. So how is the decision made? Like I said, this is a very complicated part of the process. I don't envy the employer's role in this process. So some things that you need to consider when making the decision. There's EEOC guidance, which is the Equal Employment Opportunity Commission. You have to consider any state or local laws which may limit your use of criminal information in hiring, and any state or local laws which prohibit hiring individuals with certain offenses. So there's kind of two sides of the coin there, and then your internal company policy when it comes to making decisions. So some more information about EEOC guidance. The EEOC released guidance on the use of criminal background checks in hiring in 2012. They provided some information that employers should follow when making these decisions. One was for employers to consider banning the box. Banning the box is removing the criminal history question from initial job applications. This presentation isn't so much about that, but just something to be aware of. And also factored in how employers should consider criminal history when making hiring decisions. They reference the green factors, which we'll go over in detail here in a second, and also suggest not having a bright line policy, which means not having a policy within your hiring decisions, something akin to, we don't hire anyone with a felony record. So although the EEOC has lost some recent cases that they brought suit in this, there's no sign as of yet that they'll slow down this pursuit of the issue. Now with our current administration, is not exactly a proponent of government oversight, so there may be some changes to that, but I wouldn't count on that necessarily. So the EEOC position when it comes to criminal history is that certain information has a disparate impact on minority groups, specifically arrests and criminal records. It argues that people of certain races and national origins are arrested more frequently than others outside of those groups, thus employers using such information may inappropriately cause a disparate impact on certain minority groups. It's the EEOC's position that this may constitute a violation of the Civil Rights Act. And the EEOC promotes individualized assessment when it comes to considering criminal history in a hiring decision. Part of this stems from kind of changing attitudes, or when it comes to the criminal justice system. Before the election, there were very few things that both the right and the left could agree on, but the idea that there needs to be some criminal justice reform in the country is one that was gaining traction on both sides of the aisle. There aren't many topics that both the Koch brothers and the ACLU can agree on, but they both agree that criminal justice reform is something that's needed. So getting back to the green factors, which the EEOC says an employer should consider before making an adverse hiring decision. So those green factors, the name comes from a court case, but the factors that should be considered are nature and gravity of the offense. So somebody's got a criminal record on their background. What kind of offense was it? Was it a violent offense? Was it a non-violent crime? How old is the offense? Was it something that happened a long time ago and they've not had any problems since then? They've been gainfully employed that whole time. So that's another factor that they should consider. And also job-relatedness. So is the offense something that relates to their job? So an example might be, somebody's got a driving under suspension conviction and they're not going to be in a driving position. Does that really relate to their job? Now, the EEOC doesn't offer a whole lot of guidance on specifics on how you can apply that, so they don't really say, well, if it's this old, then don't worry about it, or if it's this recent, yeah, you can worry about it. They just say that you should consider those factors when making your decision. So you also have to be conscious of any state or local laws which may impact you depending on where you are located. So some of these laws have grown out of the ban the box movement. Some of those ban the box laws not only require the removal of criminal history questions from initial job applications, but they also place additional requirements on employers when using criminal information to deny employment. So these additional requirements, unfortunately, do not always align perfectly with FCRA requirements. So depending on where you are, just because you're following the FCRA to a T does not mean you're necessarily following laws within your location. So some areas that have those additional requirements include Los Angeles, San Francisco, Massachusetts, New York State, and New York City, and Seattle, Washington. So if you're located in those areas, you might want to look at your entire process and make sure that you're covering both the FCRA and the state laws, state or local laws in your area. So on the other side of laws that limit the use of criminal history in making hiring decisions, there are some laws or regulations that prohibit the hiring of individuals in certain positions who have a particular criminal conviction. Generally, this occurs for individuals who work with a vulnerable population, so people that work with children or the elderly. There may be laws in the books that say they've got this type of conviction, they can't be hired. So if you're in one of those industries, you should be aware of any of those types of hiring restrictions. These laws may not relieve you of the responsibility of conducting an individualized assessment. So at a minimum, you want to at least document, that you took into consideration the crime that they were convicted of, and it was one of the disqualifying offenses. When the EEOC guidance came out, this actually, was brought to their attention that, there are some laws that are essentially bright line policies saying we can't hire this person, and the EEOC kind of said, well, that's too bad. But it doesn't seem likely that the EEOC would use a case like that to go after an employer, but you can't say for certain, for sure. So you should have when it comes to company policy, you should have a process in place that ensures the decision makers are following company guidelines when it comes to making a hiring decision. While you should avoid a bright line policy, like we said, you can create guidelines to assist your decision makers in the process. So an example might be a list of offenses or criteria that your organization has decided is minor enough that you can move forward with an applicant. So you may, in your hiring policy, have that if it's a nonviolent misdemeanor more than 7 years old, you can move forward in the hiring process. And you can adjust the criteria depending on the position being filled. So it doesn't have to go across all levels of the organization, but it should be consistent for each job or each tier of jobs depending on how your organization is situated. You can also create a list of offenses that trigger the individualized assessment. It should be clear in your policy and in your practice that applicants convicted of those crimes should not be automatically disqualified, but it could help as a guidance to your decision makers or even your recruiters and hiring managers to say, all right, this one I know I've got to send to the team that reviews all of these. So having those types of policies and details in place helps ensure that your program is consistent. So you're not denying one applicant for the same or similar offense of another applicant that you hired. So some employers also base adverse decisions on inconsistencies between a job application and the background screening results related to their employment or education history. Again, this is something that you should review. There isn't nearly as much laws or regulations that surround this type of decision, but it's still something that you should look at. There may be examples where the information that the person claimed and what's on the report are inconsistent, but it may not have been the applicant constantly trying to mislead you as an employer. So in some examples, an applicant may have listed a certain rate of pay, and they included a bonus or a shift differential, and then the employer, when we verify the employment, nearly always only gives us their base pay because that's what the person is guaranteed to have gotten paid. I did have a person one time who had claimed about $100,000 on her application, and when we verified the employment, it was about $45,000, and she called to dispute the information. And in the conversation with her, she said that while she did get paid $45,000, that her supervisor had told her that she was worth $100,000, so that's what she put it on her application. So I'm not exactly sure where that would fall in for trying to mislead, but in most instances, it seems that people aren't intentionally maybe trying to mislead. There's just a difference between how they list their pay and how it's confirmed. Some other examples might be, when it comes to like a date of employment, they might list sometimes a temporary agency. When we get the information from an employer, there's that gap because the employer doesn't give us that time with the temporary agency, and some people aren't as aware that, when they go from temp to hire, that that temp time will not be included with their employer. Also see situations where a company changes ownership, and the employee is not, the verification we received only gives us the time when they were a direct employee of the new owner and not their full time, even though they might not have even moved desks. I mean, I had a woman a couple of weeks ago who had essentially 3 different employers, and her job never changed the whole time. So we had to go to 3 different places to compile all of her employment, even though her job was essentially the same.
Kevin, I have somebody who has a question about misdemeanors, and she was asking if they were automatically, misdemeanors automatically ruled out, or the number of them, and was saying that they hired somebody with 12 to 15 misdemeanors. Is that something you want to comment on?
Well, again, that would fall into the company policy. Again, you'd want to look at each one. I mean, they may have had a number of misdemeanors that happened a long time ago, and they haven't had any issues since. These are things that as an employer, you have to consider, and that's part of the reason for the individualized assessment is you're taking each situation unique because they are all unique. One person with a number of misdemeanors that happened recently, you might look at differently than somebody who had a few, many years ago, and have, maybe they're coming from a place where they worked for the last 15 years without any problems. So that all comes into how you, the employer, evaluate that information. There's no specific, guidance to say, if they've only had 2, go ahead and hire them, and if they have had more than that, then you shouldn't hire them. Those are all the types of things that you'll have to decide as an employer. And again, you need to take each situation as if it's unique.
Thank you.
So once you've made your preliminary decision based on the background report, you need to notify the applicant of the potential adverse decision. You should do this in writing, or you have to do this in writing, via the pre-adverse action letter advising the applicant of the potential adverse decision, their right to dispute the accuracy of the report with the background screening company, and the contact information for the screening company. And a notice to the applicant they may provide additional information to assist the employer in making the decision. So they may look at the report. The report may be accurate, but they may wish to provide you some additional, context for the information on the report. So if the applicant provides this additional information, it should be evaluated while you're in making the hiring decision. This may include documentation of rehabilitation or additional character information. So this, the pre-adverse action letter should be sent along with a copy of the background report, a copy of the summary of rights under the SCRA, which I assume most of you are corporate screening clients on the call, that is attached to all of the reports that you receive from us. There are some cities that require the employer to note the specific information in the report that the potential decision is based. A couple of those areas are San Francisco and Los Angeles. These are things that came out of ban-the-box legislation. Also for New York City employers, among some other responsibilities, there's a specific form that needs to be provided to the applicant along with some other information related if you're using a criminal record to deny employment. We'll say that some employers, if they get a background report back and the information isn't good, or they're going to be stuck, they can't move forward, they'll email or call the applicant to try to remedy the situation quickly. Well, I understand that in spirit, you feel like you're acting in the applicant's best interest. If you're notifying them of the potential adverse decision without providing them the notices noted above, it can be viewed that you're in violation of the FCRA. So even though your intentions may be good, there's a good chance that plaintiff's attorney will take that information and say, yeah, but you told them that you were potentially not going to hire them and you did not provide them with this information. So just be aware of that when you're coming up with your policies and procedures, that the indication to the applicant that you may not be hiring them, that needs to go along with these other notices and documents. So once the notice is sent to the applicant, you need to give them a reasonable amount of time to respond. The FCRA is silent on how long you should give them, but a general consensus is that you should give them a minimum of 5 business days to respond. So if you can afford to give them a few more days, that's fine. That's good. That just gives them more time. So applicants, like we said before, have the right to dispute the accuracy of the report. So we'll go over some details of the dispute process. So they can contact us, the background screening company, or they may contact you as well as the employer. A lot of times they have a better, they have a known relationship with the employer. So even if the letter says to contact corporate screening, their first step is to contact the recruiter. So if the applicant does provide documentation that contradicts the result of the background, they may include a copy of a diploma, or maybe W-2 saying, hey, I did work here and this report says I didn't, or some court documents that contradict the information in the report. So you don't need to accept those documents at face value. If those documents are provided to you, you should send them to us to review and reinvestigate the information. While a majority of applicants are not attempting to defraud their potential employer, it does happen from time to time that we receive a copy of a diploma. We send it to the school, and the school says, that is not one of our diplomas. This person did not graduate from our school. So the big takeaway here is, you can accept these documents, but you should, get them verified. Also, if the person contacts you and they don't have any documentation, but they want to dispute the report, that's no problem. They don't need documentation. They just need to say, hey, this information isn't right. I want it looked into. So if you are notified, you should, by an applicant of a dispute, you should notify a screening company as soon as you can about the dispute. And conversely, if we're notified directly from the applicant, we notify you as the employer that the information in the report is being disputed. So once a dispute is initiated, per the FCRA, we have 30 days to complete our reinvestigation. We're acutely aware of the importance of this information, so we endeavor to get them done as soon as possible, and on average, a majority of them are completed within 2 to 5 days, some even faster than that. So if the dispute is confirmed, meaning that the applicant is correct, that the information in the report was inaccurate, the report will be adjusted to reflect the accurate information. You'll be notified of that adjustment, and you should treat that disputed information essentially as if it never existed. If the information is reconfirmed, then the report will remain as is. You can go forward with your decision making. And then if the third outcome is the information can't be reconfirmed, it needs to be removed. So it's not confirmed, it's not changed, but it's also not reconfirmed, then it has to be removed. And no matter the result, both you, the employer, and the applicant are notified of the result of the reinvestigation. So adverse action. I know it can get a little confusing because the whole process is called adverse action, but one of the steps is also adverse action. But this is the mechanism where the person is, the actual adverse action is taken. So if the applicant does not respond to the pre-adverse action notice within the allotted time period, or you've evaluated additional information that they've provided, and the dispute's been resolved, and you still want to go forward with your adverse decision, you have to notify them of your final decision. So the notice, notifies them that the decision was not made by the background screening company, and we also recommend you to send them another copy of the report and any other state notices. You've got an opportunity to make sure they get a copy of their report. You should always take it. So you should document your process. This should include, documenting the date when notices were sent to applicants, copies of the notices, any documents related to your assessment, and anything else related, to how you made your decision. You want to keep that information. Corporate screening, here at Corporate Screening, we offer a tool to help you with that process. So it helps you create and send out the letters, including some of the state-specific notices that you may need. So to sum up, we recommend that you document a policy and procedure for making your decisions based on the background screening results. You should review your policy and procedure with legal counsel, and you should regularly train and notify your staff of their role in the process. So that sums up everything. Sarah, I don't know if we had any questions.
Yeah, we do have a few questions. And Kevin, could you go to the next slide, please?
Oh, I'm sorry. There you go.
That's fine. I just wanted everybody to be able to see Kevin's contact information. And I wanted to thank you, Kevin, for all of the helpful information, and thank everybody who was here taking the webinar. I do have a whole list of questions that I'm going to get to in just one second. But if you do have any questions or you need more information, you can contact Kevin, and his contact information is right on the screen. So I will let you look at it, and I'll review it right before we wind up with the conference call, the webinar. I do have a few questions. The first one is about the FCRA. What if the FCRA has a rule in place and it conflicts with state laws? How is that handled? Does one overrule the other? Can you review that a little bit with everybody, Kevin?
Well, yeah, that would be a tough one. I need to know a little more specific regarding the particular situation. I mean, in general, federal law overrules state law, but when it comes to the FCRA with some information, there are state laws that are more strict than the FCRA. So I need to know a little bit more details on the specific situation the person's referring to. So if they want to send me an email there with a specific situation, I'd be happy to answer it.
Great. Thanks.